Prior to beginning with the session, just for the convenience of the audience, I'll briefly delineate what the structure of the session would be. Part one would have our honorable speakers deliver their opening statements as well as their views, and that would last for a period of 15 minutes for each individual speaker. Part two would have the speakers reflect upon each other's observations with possible questions from me if that is suitable at the time. And during part three, we'll open the floor for questions and we'll also be awarding certain books that you may see here to the students who ask the most engaging questions. So we would urge the students to have a thorough discussion and engagement with our esteemed speakers. And for the virtual students, we would also ask you to put your questions in the chat box and we'll try to answer them towards the end of the session. Now, before we begin with our session, I'll briefly set the context as to our present discussion here today, which is the administration of death penalty in India. I'll begin by quoting the French author Victor Hugo, who in his novel, The Last Day of a Condemned Man, wrote that it is nothing to die, it is dreadful not to live. And this single line captures the essence of what death penalty signifies. It merely not signifies the extinguishing of biological life, but it also signifies the stripping away of the possibility of life, of a future. And it does not speak to whether capital punishment is just or unjust, but it speaks to its existential finality. And therefore, capital punishment is intended to represent the highest form of deterrence, cutting against the most basic of human rights, that is, the right to life. And international governance espouse for the protection of this right. And they also allow a state to have the concession to cause a deprivation of this right, but only with the strict adherence to lawful machinery and procedure that does not cause a denial of human rights in the process. And Indian law has long juridically treated the death penalty as an exceptional punishment that is to be used only in the rarest of rare cases. And we have a doctrine for that, which was crystallized in Bachchan Singh versus State of Punjab 55 years ago. However, our session today will not confine itself to doctrines and the legal letter alone. Our honorable speakers would talk about a variety of procedural, social, and human dimensions, including practical realities, judicial trends, fair representation and sentencing, lived experiences of death row inmates, evidentiary limitations, and social psychological ramifications of being convicted for death, among others. I will now first invite Sir to present their opening remarks and perspectives. Sir, you may please begin.
Thank you very much. It's good to be with you all, and I apologize that I was not able to join in physically, which was the original plan, but due to a rarest of the rare requirement in Bangalore, I was required to travel. But thank you for having me, and it's a pleasure to be sharing this panel space with Shreya, who's done path-breaking work in this sphere. And I'm also pleased that all of you as a student community have taken on this topic head on, and have also given us the liberty to move beyond just, the jurisprudence and the doctrines, and possibly get into a little bit of our personal reflections on this side of the law. Of course, the moderator has cut down our speaking time from 25 to 15 minutes right now, and I'll stick to that instruction. Probably cover some of the other points in the discussion later. Now, I noticed that Shreya's new outfit has changed from being 39A to square circle. And I'm wondering whether it's because of the square peg in a round hole that is the death penalty jurisprudence in India. I don't know if that was the idea behind it, but it struck me that that might be the best summation of what we grapple with in death penalty cases. Because you have one side of the law which is pulling in a particular direction, which is the Supreme Court's laying down of precedents and principles in this sphere, which is to move away from death as much as possible and become what we are now called as a de facto abolitionist state, which is that we have the death penalty in the book, de jure, but in fact, we practically do not have it, with a few exceptions now and then. But on the other hand, you have legislature and policy pulling in a completely different direction, which is to up the ante, to increase the number of offenses that award death, and try and postulate and posture that as the strong arm state that we are trying to project ourselves as. And there's a clear dichotomy there. And especially in a matter of such serious significance, which is literally one of life and death, to have your parliament, executive, your policy pulling in one direction, and to have the courts pulling in another, I think is really that square peg in a round hole in which this death penalty practice finds itself. Even within the courts, and I'm sure you will hear statistics later, the approach of the trial courts, of the high courts, and the Supreme Court differs. And it's invariably at the Supreme Court level that in those cases where the High Court on reference confirms a death penalty, that the Supreme Court then goes out on a limb, invoking principles of mitigation to try and commute death to life, even in cases where conviction is required to be upheld. And that's really been, in a way, the substantial march of the law. I won't go into the doctrinal parts, except to say that these two court-made principles, one is the rarest of the rare, which has been, again, subjected to much varied and discretionary and even contradictory interpretation by the courts, and the doctrine of mitigation, which is to look at the conduct of the accused, to look at the antecedents, to look at the social background, to look at their conduct while in jail, to look at their mental capacity, etc., etc., and then use one or all of them to reduce death to life. And this is happening as a matter of tradition, if I may say, in the Supreme Court. The only difficult part there is, for me as a practitioner, that something as serious as this ought not to still rest in the realm of tradition and custom. It could have ideally found a voice in some statutory codification, if not constitutional. And this is something I had proposed when I was part of the review, the subcommittee on the new criminal laws, where I was called in as an expert, and I took liberty to propose that this would be an ideal situation for Parliament, while looking at an overhaul of criminal law, to actually go back to the question of whether we need the death penalty at all, to look at Justice Shah's committee report, to look at Justice Verma's report, and look at a trend worldwide, and try and actually move towards an abolition by a constitutional amendment, so that there is no discretion even with governments that come and go. As you know, amendment of a constitution is harder than a statute, and literally set it in stone. Of course, the output was very different. As I mentioned, the number of offenses that now attract death has been increased in the new BNS. So it has jumped to, I think, 16 or 18 or so. And that shows you the disconnect. And Mamata Banerjee's Aparajita bill after the RJ Kaur case was a knee-jerk reaction of the state to say, we will grant death in case of rape cases. And of course, that went to the governor and is awaiting approval because of other issues relating to repugnancy, etc. But the point is that this is how decision makers and lawmakers tend to see death. They tend to see it as a stick to beat society with, as a deterrent, which frankly it has not proved to be. The most serious problem with this is the fact that we tend to get death sentencing wrong. Now, mitigation is only a commutation of the offense from death to life. I had recently appeared in a case where, in case of an honor killing, a father who had brutally murdered his 9 months pregnant daughter, was given death up to the High Court, but his sentence was commuted from death to life, basis mitigating factors, though the conviction itself was upheld as being a very sharp case, and the conviction was for life without remission. But the fact is that there are also cases where courts are frequently converting death penalties to acquittals. And that's where the problem lies. This particular realm of the law has to be zero error. You cannot afford to get this wrong. And you look at the studies in the US where race-based convictions have led to so many grievous errors made by the courts there. We don't want to follow suit. And that's where the courts have, again, even at the Supreme Court stage, gone back to an appreciation of evidence, and in many cases granted acquittals in cases of death penalty. One of those cases I had an occasion to appear for the project, which was Munna Pandey's case, which lays down cardinal principles of fair trial. And that was a case where concurrent findings on death were reversed. The matter was remanded to the High Court for a reconsideration, and quickly thereafter, an acquittal followed. And this was a shocking case. And I want to use this to bring in the part of advocacy and legal aid in such cases. The shocking part was this was, of course, a very heinous offense, which was the rape and brutal murder of a minor. But the disturbing part was that the conviction took place of this gentleman, Munna Pandey, on the circumstantial evidence, on the oral evidence of certain family members, etc., none of whom had seen him commit the offense. There was no forensic. All of their statements initially in the 161 had named somebody else. And when they deposed on oath in court, there were improvements. And instead of the individual who was a minor originally named, we now found two names. And the peculiar part in this case was that the minor, of course, was let off in lieu of the lighter provisions of the Juvenile Justice Act. And this individual, who had been named for the first time in the oral evidence before the court, ended up suffering not only a conviction but concurrent death sentences up to the High Court. And the basic defense advocacy that would be required in such a case would be to confront the 161 statement to those witnesses and say, here is an apparent improvement / contradiction. And trust me, friends, this kind of a contradiction or a lacuna in the prosecution side sometimes can be good enough even to quash a case. You may not even have to go through trial. In a 482 before a slightly liberal bench, you might even have a quashing of a case without trial, saying, look, circumstantial evidence, no direct evidence, no eyewitness, no forensic, no scientific evidence. Brazen differences and improvements between the 161 and the testimony, invoke 482 and quash it. But unfortunately, the defense counsel, private and legal aid, did not discharge that duty, did not confront those contradictions. Sadly, the courts also didn't look at it. And that's a separate session for you someday as to the role of the Sessions Court and the trial court in itself as being one that moves towards discovering and uncovering the truth of the matter, as opposed to simply recording the adversarial submissions on both sides and coming to a conclusion. So neither the court nor the counsel discharged that duty, and instead convicted, obviously, with the weight of the gravity of the offense, the very, very brutal nature of the offense, and the fact that the prime accused had already then been let off. And friends, here I think the role of legal aid, of advocacy comes in quite sharply. That's where Project 39, now Square Circle, fills that gap. And 39A, as you know, in the Constitution, is really an article providing for legal aid. And what better space in the law than the death penalty space to provide this legal aid? And this is important not only in terms of the manner in which trials are conducted, defense is led, etc., but there's also an onus, I think, when it comes to award of bail. I mentioned to you earlier this dichotomy between statutes moving towards more serious punishments and death, and court laid law and court made law moving towards uh, acquittal slash mitigation, etc. It's not just theoretical that number of offenses with death has increased. It's not just a theoretical move. You may sit back and say, so what? We are de facto abolitionist anyway. So whether there are 12, 16, or 60 offenses, invariably in the Supreme Court, you will have an acquittal. No. One is, of course, the psychological impact that these cases have on the accused. That again is a long and a separate conversation in itself. Merely getting an acquittal in the Supreme Court, no doubt, is a lease of life to someone, but the damage is done. Even in this Munna Pandey's case, the social stigma, being ostracized from the community, not having jobs, those are irreversible. And trust me, empirically, these convictions only happen at a certain socio-economic slash caste strata. I have not come across in my career, at least, directly or through research, industrialists or high-flying businessmen, or for that matter, politicians having suffered death penalties. So there's that aspect. The other part is the advocacy, not only in defense, but also in bail. When you make offenses more stringent, you increase the penalty to death, then the likelihood of your getting bail becomes that much tougher. It's tough as it is under special enactments like UAPA, PMLA, etc., where you have the reverse burden. It's tough where an offense like 302 is invoked or some other serious offense is invoked, POXO. But the moment you have more offenses with death, then the onus on the trial court to grant bail becomes heavier, and the reasons to be awarded ought to be more sound. And this, again, I'm saying more from practice. I think this might be 60-40. It's 60% a psychological impact that it has on the bench, probably 40% the law. But the fact is this, that the moment a court is confronted with a bail petition in a case where the sentence is death, I think, my guess is that the odds of getting bail becomes that much more difficult. And therefore, the role of counsel, the role of the legal aid or of pro bono advocacy becomes, I think, that much more important. I'm probably already into the 15 minutes that I was allotted, but I'll make one other point here, which is that since you're discussing this in the context of a human rights clinic, and that's really at the heart of this practice, is to consider two or three things. One I've already mentioned is the importance of a serious role of a defense counsel. It cannot be treated lightly. Comes with that is the body of work and the experience that you have. I've said this in other places before, that people think many times, all of us colleagues, that if you're doing a matter pro bono, you're doing somebody a favor. I would urge you very strongly not to see it in that light. Fee is a factor in your engagement. It's your personal discretion whether to do a case pro bono or not. But once you choose to do it, then your commitment and your expertise and your effort has to be the same. If anything, it should be higher in a pro bono case, but naturally you're dealing with a more difficult situation. You're dealing with an underprivileged client. You're dealing with a sharper set of facts. And that's where, please don't have this impression that pro bono, you just walk into a sessions court and say, I'll take this on. I'm forgetting what that, my cousin Vinny. You can't be that sort of lawyer, please. It has to come with some gravitas and seriousness. And alongside that will also come the ethical challenges that you face. Suffice it to say that these are difficult cases to take up. Please don't think counsels just do them like a piece of cake. When you are confronted with a serious offense of this nature, when you see the post-mortem, you see sometimes photographs, video evidence, etc., it makes your stomach churn. These are brutal, brutal offenses. And obviously, victims are also an important part of our system that can never be disregarded. So you need to be able to make those ethical choices that, yes, despite this, I'm willing to do this matter. And you do this also knowing that you're actually discharging your ethical duty to its fullest, because in many of these cases, on totality, on evidence, these are not even cases for conviction, they are cases for acquittal. But you need to be able to walk that line. And if you have an ethical issue with it, you have worse still, a personal moral issue with it, please don't touch those matters. Don't do them half the house. You'll be doing a great disservice. And you will also, friends, find blowback. You might get trolled sometimes. You might get criticized sometimes for taking up these offenses because they're seen as being offenses against society. But you have to then be very clear and have that skin to know the difference between your ethical obligations and what perception, media, society, etc., is. I think I'll stop here and let Shreya take over.
Thank you so much, sir, for that wonderful insight. Now, we would like to hear from you. Thank you.
Hi, everyone. Thank you so much for inviting me. A big thank you to UPS and to the student committee and the Pro Bono Club for organizing, a debate and a discussion on a topic so relevant to our times. It is, of course, a tall order following Mr. Sondhi and his very articulate remarks. I would like to say, given the discussion and what Sir has just mentioned, the work of Project 39A now as Square Circle in being able to do the kind of defense that we are able to provide to many of those who are on death row is made possible only because of the spirit of pro bono that exists among so many in the legal profession. And I just want to echo Sir's remarks on that it's very important that we take up this kind of work with the solemn vow that it needs to devote the time and effort that these cases require. So I was thinking about what I should talk to you guys about this afternoon, and I felt like maybe what might be useful is for me to somewhere reflect on my own journey on this. So I believe maybe some of you know this already, but we at Project 39A, we began actually as a student-led project. This was back in the June of 2013 that a project was proposed to study who is India sentencing to death and what is the experience of those who are on death row in our country. Now, mind you, up until now, I mean, this was about 11 years ago now, up until then, we had a sense, intuitive sense, that it is the most marginalized who are sentenced to death. And that is the lived experience across the world. But a study of this nature, a pan-India study, was yet to be conducted. And it was, the generous spirit of NLU Delhi, National Law University Delhi, and the then Vice Chancellor, Dr. Ranbir Singh, to approve a project of this scale, which is what led to the creation of Project 39A as a criminal justice center. Because when we started in June 2013, we didn't know this would end up being a 3-year-long research study. And actually, it was when it started, we had no idea, no intention that we would end up taking on the cases of these people whose lives we were studying, who are people that we would interview. And the reason to take that on as legal intervention was because amongst the many things that we discovered in our research study, what we found, what was most appalling to us, was the abysmal nature of legal representation that those who are on death row receive. And I just want to share a few narratives here with you all. Some data points, right? First and foremost, the most shocking thing for us was that many of those who ended up receiving the death sentence, many of them actually quite intuitively, we would think that these would be people who would have been represented by legal aid lawyers, because I think generally there is this idea in our country that the poor often just take on legal aid. But quite counterintuitively, what we found was that majority of those who were sentenced to death at the trial court level, they actually did not opt for legal aid. They actually opted for private representation. And the reason for that actually was because there is a deep-seated fear of legal aid in our country. Many people, even though they are economically quite vulnerable, they, instead of going for state provided legal aid, they went and opted for private representation. And this also did not in some way change the kind of or the nature of legal representation that they were provided. Because what we have now found in our work, not just through research but also through through the legal work, legal intervention work that we do, both at the Supreme Court level but also at the trial level in Maharashtra particularly, is that there is this idea that it is legal aid which is poor in nature and private representation is somehow of better quality. That really is a myth, because it depends on the kind of lawyer that you have, that sir was talking of, and what efforts that lawyer makes, irrespective of whether they are a legal aid appointed lawyer or a privately appointed lawyer. So this was one aspect. The other aspect was that as the people moved up in the criminal justice system, what also became very clear to us was that there is a wide gap in how much they understand and they are able to engage with the legal aid system. Because most of the times people told us that their lawyers, even at the trial court level, their lawyers never came and met them in prisons. Their lawyers never explained to them what was the evidence against them. They didn't understand the court proceedings. There were often times that they would be taken to court, but they're never really produced in court, even though their attendance is taken. Right. And what this really meant was that the person who is the accused, who is finally being sentenced to death, is the most irrelevant person in some ways within the trial process, because they don't understand what is happening in that process itself. Right. And so these were things that really shocked us, and that is why we took upon this challenge now of the last 11 years to start taking on these cases and build a community of lawyers, a network of a very vibrant a network of advocate on records and senior advocates who all devote their time to these cases entirely pro bono and provide the best possible representation to these prisoners. Now, what is it that we have found through the research work as well as through the representation work that we do? And at this point, I was reminded today of the prophetic words of Justice Bhagwati in his dissent in Bachchan Singh. So for those of you who may not know this, the last time the constitutionality of the death penalty in India was determined was in 1980, in May of 1980, which is when by a 4:1 bench ratio, the court upheld that the death penalty was constitutional, and which is where the doctrine that Sir mentioned of rarest of rare was first alluded to. Now, the words rarest of rare, it is definitely for those of you who are interested in issues of death penalty, I would recommend that you read not only the majority decision that came out in May of 1980, but about 2 years later is when Justice Bhagwati's dissent, that he authored, came out. And it took him, he begins his dissent by saying that he didn't realize that it would take him almost 2 years to write that dissent. And it is certainly something worth reading, because today what I'll tell you is that in the last 45 years, when you map on the experience of the death penalty in India, both in terms of how its administration has happened judicially, legislatively, in terms of policy, or even the research that has come out, What it tells us is that today, the words of Justice Bhagwati and the concerns he had, which is why he thought that the death penalty is unconstitutional back in 1982, they are truer today than the words of the majority. And the two main concerns that Justice Bhagwati had were, firstly, he believed that the death penalty is a inhumane punishment. He thought of that because, of course, of the issue of the fallibility of the death penalty, that can we really be sure that we are not going to be sentencing an innocent person to death? Now, sir has already mentioned this, and I think just to give more empirical data here, in the Death Penalty India report that we came out with, our flagship work, part of that was also for us to look at, apart from interviewing the prisoners on death row from 2013 to 2015, that was one part of the report. The other part of the report was we looked at 15-year data from 2000 to 2015 to see what is the outcome of death penalty cases as they move up through the judicial process. And what we found here was that about 30% of the cases end up in acquittals, right? So that is 1/3 of the cases, almost 1/3 of the cases resulting in acquittals is such a sharp number, because the question I would have for you is that if I was to tell you that, a specific airline, the flights in that airline fail and they crash 1/3 of the times, would you ever take that airline to fly, right? I mean, just put it in that kind of perspective. And this is the national figure. What we found was that in some of the state, when you divide this number, when you look at it state-wise, the numbers become even more alarming. For instance, in the Patna High Court, the High Court had an acquittal rate of 49.5%. Right? That's half of the cases, death penalty cases, that go from being sentenced to death to being acquitted. Now, these could be acquittals which are because the court finds that these persons are actually innocent, that there is new information, new evidence that has emerged before the court which points to their innocence, or it is because the prosecution did not meet its burden, or that there were very serious lapses in investigation. But irrespective, it is an acquittal, right? So that was one of the main issues that Justice Bhagwati had, the inherent fallibility. And I think data has just proved that 10 times over. The other big thing was, and sir also mentioned this, is the entire process of being sentenced to death. What does that do to a person's psyche? Now, here I'd encourage you all to look at our research, both the Death Penalty India report as well as our work on Deathworthy, a mental health perspective on death penalty, which is where we looked at across 5 states. We interviewed prisoners on death row to see what is their experience of being in prisons, and what's the prevalence of mental illness and intellectual disability amongst death row population. And here we find that more than 62% of prisoners either have a mental illness or they are intellectually disabled. Now, both of these are two very different things, of course. And some of this is, mental illnesses are illnesses which are not something that they had as they entered the criminal justice system, but something that developed in prison itself. And all of these really tell us something about what it is for that individual to experience death row. So for a country where the right to life is the most paramount, and there are so many, that we come from a rich constitutional history of right to dignity being protected in all contexts. That is where this kind of experience of the death row phenomenon really comes into sharp contrast. The last thing that Justice Bhagwati talked about was the inherent unfairness of the death penalty, right? And this would be the last remark that I'll make before we break for questions. So he talked about, the words he used was that despite the protections that were created in the then new Code of Criminal Procedure, Section 354(3) of the CRPC, what he believed was that it still did not provide enough guidance, and he called it unguided, standardless discretion of judges. And this is something that, again, there are so many decisions, so many reports which have come out on this, starting from, of course, the PUCL amnesty report, which looked at Supreme Court decisions, or also the Project 39A reports, both at the trial court level but also at the Supreme Court level, which show a wide disparity in the way in which courts look at rarest of rare and understand rarest of rare. There is a lot of subjective philosophy of judges which is at play. Now, I should say that the Supreme Court in the last few years, and especially since 2022, when the decision in Manoj versus State of Madhya Pradesh came out, that the court is becoming again more cognizant of this and is trying to bring into play through the creation of practical guidelines for trial courts to be followed, that the court is trying to bring back some fairness in the process in which we sentence people to death. And the attempt here is that we see a lot of the sentencing in death penalty cases happen because there is a fixation on the aggravating factors, where the courts are only looking at factors relating to the crime, but not really factors relating to the criminal, which is what the Constitutional Bench in Bachchan Singh required courts to do. And the big reason for that is because unless and until we have a procedure which allows for rich life history of the individual to come before the court, unless and until that is truly followed across all capital trials, we will not have that weighing exercise of mitigating and aggravating factor truly happening in courts, which is why in Manoj the courts came out with those trial court guidelines. Now, what we have seen in our research is that even though those guidelines have come into place, and those guidelines again require for different type of reports to come before the court. There are reports of the psychological evaluation of the prisoner. There are jail conduct reports, as well as report of the probation officer. The court has also recognized, the Supreme Court also recognized, that the defense needs to be given that access as well, and which is where mitigation investigators, so these could be individuals who come from different social science backgrounds, that they can go to the prison and interview prisoners. Their reports can also be brought before the court. However, the big question here is that even though the Supreme Court's come out with these guidelines, their compliance at the trial court level just does not happen. Right? So in our last annual statistics report, we saw that in 2024, out of the 139 prisoners and capital trials that happened across since 22, 23, and 2024, we find that only in mere 11 or 12 cases that there is partial compliance with the Manoj guidelines. So in most of the cases at the trial court level, we still aren't seeing these reports being called for. And the big reason for that is probably because we also don't even have institutional capacity to call for these reports. Because today we are still grappling with issues of having access to a lawyer itself, let alone access to a psychologist, a psychiatrist, a mitigation investor, etc. So the big question here is that while our jurisprudence, there is a search for fairness in our jurisprudence, and especially the jurisprudence of the Supreme Court, are we really any closer to that becoming a reality at the trial court level? And my answer to that is, we're far from it. So I'll stop there, and I look forward to the discussion that will now ensue.
Thank you so much, ma'am, for that insightful engagement. And before we begin with our reflections, I just wanted to ask a question to the both of you. And this is in furtherance to both of your reflections. Like, when in preparation for this session, I was reading the 8th edition of the death penalty report, which is authored by Project 39A. I saw something wherein, like, as sir stated, there's a gulf between legislature, that the fact is that we're having more and more crimes which have death penalty as a form of punishment, and the judiciary, There's also a gulf between trial courts and appellate courts, wherein trial courts are very, I would say, eagerly awarding death penalty to individuals. Rather, the report highlighted that currently our total death row population is the highest it's ever been in the past 2 decades. And also the fact is that most of them ultimately either are commuted or either are acquitted. And at the same time, lots like based on that report, 87% of the capital cases, in those cases, no mitigatory evidence was brought in favor of the accused. So I just wanted to know both of your perspectives on as to why this is happening and why we have such a different disconnection between how the trial courts are operating and how the appellate courts are, and why it is so difficult for accused to have some sort of mitigatory evidence being provided in their defense by their very own lawyers. We can begin with Sir, then followed by Mark. Thank you.
See, in fact, the emphasis seems to be on mitigation in death penalty offenses. I want to take the conversation a little further to mitigation in non-death offenses. It's an equally important facet. If there are mitigating factors that come into play for death, they should logically come into play even for life. And the bigger question, therefore, is what sort of sentencing jurisprudence have we focused on and developed in our criminal justice system? And that was, in fact, a question I wanted to raise and discuss with Shreya and all of you, which is that are we at a stage now where we need sentencing councils like you have in other jurisdictions, comprising judicial members, criminologists, psychologists, and experts who come up with practically binding guidelines. Of course, judges are not 100% bound, but they need to give reasons to differ from those guidelines in matters of sentencing. And those inbuilt in those is mitigation and the application of a more empirical, of a more objective manner of sentencing. And that would apply then across the board to death and non-death. And we're quite a far cry from that. The focus on sentencing, and you must have seen judgments of the Supreme Court which have said that a reasonable opportunity must be given to an accused to make their submissions on the sentence. So between conviction and sentence is a very crucial stage of natural justice, of due process, of hearing. You don't just jump the gun and say, all right, it's a case for conviction. Therefore, logically, as a sequitur, it's a case for death. No. An accused must have a chance, a counsel must have a chance to reflect and argue and say, all right, the evidence shows conviction, but these are the reasons why a particular sentence is in order. And I was reminded anecdotally when you asked this question, as the moderator of a session I was at the Judicial Academy in Bhopal some years ago on criminal jurisprudence, and a retired judge of the Delhi High Court, who I can't name, who had sat on the criminal roster as a sessions judge and also as a appellate high court judge, he was speaking to sessions judges. And he said very candidly, he said, Dekho bhai, I assume everybody understands Hindi here. He said, Dekho bhai, aap सेशंस कोर्ट में 10 साल देंगे तो वो हाई कोर्ट में 8 साल हो जाएगा, वो सुप्रीम कोर्ट में जाके 6 साल हो जाएगा, इसीलिए ज्यादा दो, जैसे ऊपर जाएगा वो कम होता जाएगा. And he also in a sense encouraged the sessions judges in a way to be trigger happy, and he said आप डेथ दोगे तो हाई कोर्ट में वो लाइफ हो जाएगा. But this kind of casual approach on a matter of life and death, you have already heard the very serious impact it has on an individual. If you're on death row, and there's so much literature, cinema, plays, etc. on this that you'll read, the impact that it has on being on death row itself can be debilitating. So to answer your question, I think in the trial courts, perhaps that disconnect is there because we've not focused enough on criminology, on the criminology of sentencing jurisprudence. And of course, the change has to come from within. It has to come from the bar also. The bar's role, the advocacy in this matters is important, but I dare say there is a need also for structural correction, and sentencing councils may be one such answer.
Ma'am, you may proceed.
Yeah, I mean, absolutely. Just to piggyback on Sir's point and offer two other aspects on this. One would be, I think there's, like what I was saying earlier, there's just no capacity, right? So we need to first understand. I mean, apart from the attitudinal change and the fact that we need law, and then we need policy around that, and then we need training of judges on sentencing, all of which is severely lacking. Apart from that, there's also the question of that: do we see sentencing as a space which is actually not just of law and of lawyers? There are so many, like, what I mean by that is that there's so much in the practice of law that is actually beyond the realm of the law as a discipline, right? Legal practice is quite interdisciplinary in nature, and the future of legal practice across different aspects requires the expertise of different kinds of individuals. So now that we're talking about sentencing, what it needs would be, it needs the expertise of psychologists, of psychiatrists, of social workers, of criminologists, of anthropologists. Do we have enough of those kinds of professionals, A, in India? B, have we created pathways of their integration into the legal system, right? So there's a lot of work which is required on that front. Mitigation as a profession itself, which, for instance, if some of you look this up, in countries like the United States, you have and again, the US is a very curious example, because it's not as if across all 50 states that you have the death penalty. It is only in some pockets that now the death penalty remains. And while there are a lot of problems there, of course, one of the things that you look at in the practice of the death penalty in the US is there's been a lot of discussion about access to mitigation investigators, which has been judicially recognized. And that has become a profession in and of itself, right? Now, mitigation investigators is now a budding profession in India, and we just have very few people who are associated in the death penalty space in that regard. So I think we need work on that. The second thing that I'd very quickly say is, I think we also need better rules and regulations about around the way in which prosecutorial discretion is used. The reason I say that is because what followed post Manoj in one of the cases, which finally where the Supreme Court took suo moto cognizance as now and has now referred the question of institutional capacity and the stage at which mitigation should happen to a 5-judge bench. As part of those proceedings, one of the things that the Supreme Court took cognizance of was that there are states in India, and particularly here they were talking about Madhya Pradesh, where there was a formal policy in place since 2018, which incentivized prosecutors to ask for the death penalty. There was and many of you can look this up, this policy which gave prosecutors 1,000 points if they got the death penalty, and 500 points if they got life imprisonment, and negative points if they got an acquittal in one of their cases. Now, this is the fact that the Supreme Court had to strike this down in the year 2023 is appalling in and of itself, right? That a policy like this could exist. While this was a formal policy, I'm sure that attitudes like this still exist across all other states, which can't be struck down. And we need better laws and regulations to make sure that our prosecutors are in favor of fairness and justice, rather than seeking, higher punishments. Yeah.
Thank you both for your insightful perspective on that. And like as both of you have stated, I also like during my research found that most of the death sentences that the trial court does give are given within a day or a week. They usually don't hold a separate hearing for giving such a high form of punishment, which is essentially you're going to extinguish someone's life. And a greater amount of time should ideally be given to be able to decide whether a person who has been convicted should they be sentenced to death or not. And generally, as the report stated, less than 46% of the cases actually go beyond a week. Most of them are decided within a day. And I wanted to carry this discussion forward in that direction. Like, this is a question for Sir. Ma'am can also speak to their experience after Sir's response. Like, I also found that when it comes to mercy petitions, there's a lot of delay that is happening. And there was a case in the Supreme Court, that is State of Maharashtra versus Pradeep Kokade, wherein the Supreme Court stated that when there's undue delay in the grant of mercy petitions, that is the ground for commutation. And there was an example within the report which stated that accused, since the past 17 years, they've been languishing behind the jail and their mercy petition is still to be reviewed. And the court has asked for a dedicated cell to be created to review these mercy petitions and then send them forward to governors and presidential secretariats. I just wanted to ask Sir in his experience as to what are the ground realities when it comes to mercy petitions and how they're processed, and then ma'am can also give her experience to that. Thank you.
Yeah, two or three things here. And with the recent judgment of the Supreme Court on the role of the governor in Tamil Nadu, you find that the moment these cases shift from judicial decision making to the discretion of constitutional functionaries like the governor or the president, the ball game changes because of the limited scope for judicial intervention, unwritten precedents and customs in the manner in which these matters are to be decided. And that has a spiraling effect on the rights of the accused or the convicts. And the Supreme Court also in the Rajiv Gandhi murder case has laid down the same principle that inordinate delay vitiates the process, and governors or the president must act with reasonable alacrity, even if the constitution does not prescribe a time limit. And there are consequences that follow. And really, in some way, this was the point that I also wanted to make, that a lot of this is emerging from court-made law. When we underwent this large-scale criminal law reform, there was a golden opportunity to codify all this. Right from this rarest, all right, you're not abolishing death, fine. Short of that, right from the rarest of the rare criteria to how and what constitutes mitigation and its process, how there should be sentencing councils, how there should be fair hearings between conviction and sentencing, and even for that matter, how post-conviction processes must work, including mercy, remission. They all have their own context. Remission is an executive act of the government. Every state has its own policy. The Supreme Court has been laying down principles there. I appear for the Delhi government, in fact, on matters where remission files are pending, and that matter is sub judice in the Supreme Court. And as much as mercy jurisdiction is within the Constitution, to the extent that the Constitution is silent, there was scope for Parliament to look at this and say either we build this into the Constitution itself, or to the extent the Constitution permits, build it into legislation so that these matters are not left to discretions of benches, of officials, of governors, of authorities in power. And a related point I would also like to make here is that what sort of tort jurisdiction have we, jurisprudence have we developed to, grant some kind of reparation also? You have a malicious prosecution provision in law where an aggrieved person has a right to sue for damages if it is found that a prosecution has been malicious. But not every prosecution can be shown to be malicious. Even short of malicious, there could be a failing on the part of the state or the system. And if you're now in these cases that we've already discussed, converting death to an acquittal, then what sort of restitution are you providing? You have heard recently of Justice Oak's bench awarding 10 lakhs as compensation in those cases where there were unlawful demolitions. That's a different problem of the breakdown of rule of law. But in this, I think there is also another vacuum that we need to discuss, which is how do you reintegrate people back into society? I'm not only speaking of monetary compensation here. Are you able to provide some kind of compassionate employment? Make sure the children are off the street and in schools. These are the realities of it. Yeah.
Thank you, sir. Ma'am, if you would like to add something.
Yeah. So I mean, Virendra, it's an interesting point when you look at the Supreme Court, what it has been doing in the post-mercy space, right? And the reason I wanted to talk about that was just to first kind of bring it to everyone's notice. In the new BNSS, we see under Section 372, subclause 7, and this is a provision which I believe will probably be struck down at some point or the other. There is there's a provision, subsection says that no appeal shall lie in court against the order of the president or governor made under 72 or 161 of the Constitution, and it shall be final, and any question as to arriving of the decision by the president or governor shall not be inquired into by any court. Now, the reason I raise this is because there's obviously a move in this section. There is a move towards making the filing of mercy petitions and the decision making around mercy petitions more time bound, because the big problem has been that even after people are sentenced to death and their death sentence is finally confirmed at the highest level after the rejection of their review or their curative, even after that, when the mercy then is filed, takes a very long time. And once the mercy is rejected, then people come back to the court and somehow get a benefit and get a commutation. Now, we need to map onto when we see legislative provisions being introduced in this nature, we need to see what is it that led the highest court of the land to develop a post-mercy jurisprudence. Now, the reason for that actually was that there are many factors which emanate in these cases, which have a direct impact on a person's fundamental right. And again, this is somewhere the court, respecting due process and rule of law and keeping that at the highest pedestal when it comes to matters relating to a person's life itself, right? So when we've seen the rich jurisprudence that is there and has been since the 80s itself about looking at how do we look at executive delay, that executive delay itself shows that a person was in an unknown space about what is going to happen with their life, because mind you, when a person's mercy petition is pending, unlike judicial proceedings where okay, what's going to happen next, when the next date is, when you're awaiting a decision on your mercy, you have absolutely no idea. And these are people who may await that decision for several years, or that decision may come very quickly. We have seen that also happening in our country, be it in the case of, when those who were finally executed in the December 16 gang rape, or Yaqub Memon himself. We saw as a country that those mercy petitions were decided with great alacrity, right? And that maybe calls into question a different kind of problem itself as to what was the thought process that was put by the highest executive functionaries in the decision making there. That could be a question that one asks in those contexts. But basically, my point is that the court has developed a rich post-mercy jurisprudence because, again, in death penalty cases, right to life in and of itself, not a facet of life, but life itself is at stake. And that is why it's the highest level of fundamental right that is known in our constitutional jurisprudence. That is why the court has developed that jurisprudence to see if there are any supervening factors, if there is any emanation of for instance, mental illness that should give rise to a lesser sentence, or the fact that this person was at some point in time confined in solitary confinement, or any other supervening factor that actually requires a lesser sentence to be imposed. Now, the direction of our Supreme Court jurisprudence on this versus the way in which the law is being developed, the legislative law, I think it's taking a divergent view, and we need to decide for ourselves how will we reconcile these two things. So that's, yeah, that's what I would say on this.
And if I may, I'm thankful to Shreya for just half a minute to have mentioned the additions in the BNSS. In fact, there are provisions now which deal with the process of the time frames for filing mercy petitions and they're being treated. But the question still remains, A, as to how far they would be justiciable. And the provision which bars appeal, you see, I think this is a Parliament taking a cue from Article 361 and saying because the decision of a governor is beyond question in court, you pack that into a statute. Obviously, by statute, the constitutional power of judicial review under 226 and or 32 can never be taken away. And that was frankly quite an unnecessary insertion. But the rest, of course, I think Shreya has already spelled out. Yeah. Yes, sir.
Thank you, sir. And your discussion also reminds me of the fact that within this judgment as well, the court stated that when you don't know when you're going to get or not get the mercy petition, the sort of illness that emanates from that, they refer to it as the death row phenomena. That it's a very grave form of illness that cannot be accounted for by compensation or by even acquittal in the end. And therefore, it becomes very important that a more stringent or a sentencing procedure as well as a streamlined procedure for mercy petitions is developed. And now we are opening the questions for the audience as well. And also for the virtual participants, you may put your questions in the chat box and we'll get to them as in when sir and ma'am are answering the questions. And now we would like to ask the audience if they have a question.
Somebody seems to have their hand up.
Hello, sir. Am I audible?
Yes.
Yes. So, like both ma'am and sir both talked about how there needs to be, people need to have a right to representation and adequate representation in the form of lawyers for people who are under trial. But if you see in the current scenario, most of the people who do not have a lawyer, cannot afford a lawyer, have to rely upon either a legal aid clinic or pro bono, pro bono lawyers working for me. So end of the day, I'm relying on charity of someone to get legal representation. But we have seen that in various jurisdictions in other countries, they have public defense lawyers like America, for example, like when I get charged for something, I know that I will get a lawyer from the state if I do not have one. But we do not have that kind of system in India, nor do we see much discourse happening around public legal services as such. When the Constitution supposedly talks about right to legal representation and adequate access to law and whatnot. So, what are your comments on this?
This is, in fact, reminding me of the Netflix series Adolescence, where the moment the accused is taken to prison, a legal aid defense lawyer is on call. You're right there. And there are actually questions also to be asked about how legal aid briefs are allocated. That's a different subject in itself. I'll share with you my experience when I was a young independent practitioner and I thought I had a little more time on hand because one is not very busy in the early days in practice. And I also felt it was a good time to pay it forward and do some pro bono work. I had enrolled with the Legal Services Authority. And for many years, I saw that cases were being allocated in their own manner at the whims and fancies of people in that position. And I actually ended up only doing good legal aid legal services authorities matters when I became a designated senior, when actually I had good time to devote earlier on. So one has to look at streamlining that process as well as to how cases even come to be allocated within the system that we have. How efficacious is it at the trial court level? I think that's crucially important. At the Supreme Court level, as Shreya has said, 39A has been able to put together, you know, very high quality practitioners, my fellow colleagues at the bar, who are going out beyond the call of duty many times to do these cases. But one can't take that for granted. And how professionalism in pro bono lawyering comes in, I think, is a very important discussion in itself. And yeah, that's my thought.
Thank you, sir. We have a question for you in the chat if you're able to access this thing.
Chat, is it?
It's a long question. I think it's talking about the mandatory death penalty and the fact that a lot of SC deaths occur as a result of the same, and that is violating Mithu Singh. And towards the end, they're asking that if the conclusion is that the death penalty can't create deterrence, they believe it to be erroneous because unless the death penalty is imposed, deterrence will not happen. So they are essentially saying that since we're not imposing death penalty, since there's a lot of acquittals, and as a result, the deterrence that we seek from death penalty would not happen. So he would like you to respond to that.
There's one question before that also, but let me answer this first. As to the effectiveness of death as a deterrent, look, I think if you read both Justice Shah's committee report on the abolition of death and you read Justice Verma's report after the Nirbhaya case, both in I think in very scholarly reports set out how this idea of death being a deterrent has really been a non-starter. And the fact that it is being worked out the way it is in practice, being de facto abolitionist, really tells you that the deterrent effect of death is really seriously questionable. And that is why I think in countries galore, and I don't have the figures offhand, that a large number of jurisdictions, and the US, as Shreya rightly said, is actually a different kind of an example, because in some states the maximum number of death penalties are in the US, in the southern states, in the world. But most other constitutional democracies have been moving towards abolishing through statute, abolishing through constitutional amendment, or at least undertaking partial abolition and saying, with the rare exception of, say, treason, proven terror, there shall be no death. And I think that really proves that the international mandate is that death has ceased to be of deterrent effect. Yeah.
Thank you, sir, for that. Would anyone in the audience like to ask a question?
Am I audible, sir or ma'am? I just wanted to ask to either of you, like, based on my experience in like my internships at the trial court, what I've seen and observed is that the only incentive that is there with the trial court judges to be promoted next up in the ladder, and the reason for them to get promoted, and the notion is that they need to give the strictest punishment possible, and that's how they would have a possibility to get promoted. So, like, I wanted to ask if any of you could answer that why are there such objective criteria for promotion, and like why are such kind of notions existing in the trial code? As you also mentioned that there is no compliance of such reformative jurisprudence in the lower judiciary, and which is very essential because it's very unfortunate that such kind of notions are being laid by the Supreme Court, which is the last resort that a convict would have while like waiting on a death row sentence. So, like, what are your says about that?
Let Shreya go first.
See, I think the question that you're asking in terms of why do judges decide a certain way, and specifically at the trial level, at the lower levels, I think this is I mean, it's a much needed question, but a very complicated answer, right? Because there is a lot that needs to be done differently at our lower judiciary level that I think we have as a republic, we have not managed to do. And I say that I'd like to take this slightly beyond the context of just sentencing, because something that when we're thinking of in the capital sentencing context, I mean, these are all then cases which are getting decided at the sessions court level. But even below that, at the magistracy level, right, which is where the first interaction that an accused is going to have with a judge, that the fact that it's your right to be produced before a judge within 24 hours of your arrest, right? Um, at that level, when we think of what is it that we have as a country been able to do to streamline work, to incentivize good legal professionals to take that up as a career path, and what is the independence with which we allow the judges and judiciary at that level to operate. I think on all those three fronts, I believe that there is a lot of work to be done. And part of the problem is going to be, part of the solution is also going to be that we need to ideologically and to politically be committed to allow that level of judiciary to work in a certain independent way, which it currently is, I believe, unable to do, right? And once we are able to do that, once that first level commitment exists, everything else that will follow in the nature of solutions that we need to improve standards, to improve capacities, to improve the institutional infrastructure, I think everything else will then follow from that first level commitment. um, so yeah, so I think I would say that, and I really look forward to hearing to sir's remarks on this.
Actually, I'm not personally aware of any policy which incentivizes promotions based on convictions. Shreya referred to the policy for prosecutors in MP, and that was struck down, and rightly struck down, as being unconstitutional. And if there is such a policy in a particular state, and these policies are in fact made by the High Court on the administrative side, I doubt they can stand uh, constitutional scrutiny if that's what they say. But if that is inbuilt in the psyche of judges, I've already commented on it earlier. There's also a separate issue. The High Court does frame, uh, shall we say, deadlines for the district judiciary to ensure that you meet X number of disposals within a certain time frame. And this is because of the sheer pressure of cases on our system. And this is now going beyond criminal matters. It's for all matters, civil matters, revenue matters, matrimonial, whatever it may be. Now, this again, I think, can lead to a different form of miscarriage of justice, because you are incentivizing disposal of cases. You're not really going into the quality of that disposal. And I'll tell you, I have seen many times on the civil side where suits have lingered for 10 years, 12 years. Detailed evidence has been led, documentary, oral, etc. A number of issues are framed. When you see the judgment of the trial court, it'll be an 80-page judgment. 75 pages will be a reproduction of the submissions of both sides and their pleadings, and about 4 pages of discussion on all issues. Now, technically, that is a disposal. And the judge probably earns X number of points saying, I've disposed a case. But that is not carrying the cause of justice forward. That sort of order, when it goes to the High Court, will probably be set aside at the admission stage and remanded, saying, uh, forget about the merits. There is an absence of adequate application of mind. So I think these are the practical difficulties also that one has to reflect on: the pressure to have cases disposed expeditiously, constantly trial courts. And look, you can't also blame the trial courts. For the longest time, high courts and the Supreme Court have been directing trial courts to take up X case expeditiously and dispose it. It was a larger bench of the Supreme Court which finally said, where that earlier judgment was overruled and the Asian resurfacing was overruled, and the Supreme Court said you can't really issue directions, and certainly not to the High Court, which is deemed to be on par, to dispose cases within a fixed time frame, etc. And as a result, courts have now become hesitant to issue directions. But how many times do you see a direction saying, take this case up on a day-to-day basis? And the practical difficulty of trial judges also must be seen. You prioritize, how much do you prioritize? You prioritize old cases, you prioritize cases where people are under trial, you prioritize cases where there are directions from High Court, Supreme Court. Then you hear urgent miscellaneous applications for a temporary injunction. So this actually transcends into the pragmatic difficulties in all spheres of practice.
Just very quickly, half a second, I wanted to just add something onto this, to the points of timelines that's mentioned. It would be important that everyone studies the new timelines at every stage of the criminal process that have been introduced under the BNSS. And then for us to reflect on, are these timelines in fact even possible for any judge and for our courts to currently meet? Because we have timelines like the judgment has to come out within 45 days. I mean, and really honestly, the level at which I mean the pendency exists currently and the kind of timelines that we are seeing here, it is not possible for either our police machinery to meet those timelines, or for our prosecutorial departments to meet those timelines, or our judiciary. So I think at all three levels, yeah, that impossibility exists.
That's a very important point. If I can just also step in here, in a number of trials under UAPA, for example, where I'm seeing the number of witnesses cited sometimes runs into hundreds. There are 20 TB pen drive of data and documentary evidence. Now, if you fix these time frames on paper, it's very good to say, look, we want to justice, must be seen to be done, etc., etc. That's fine. Now, look at it from the trial judge's point of view. If you don't meet that deadline, you failed in a way. Worse still, how do you meet that deadline? Is it humanly possible to assess the evidence of hundreds of witnesses and this volume of material objects of documentary evidence and write a judgment within 45 days? I could barely write a project in law school in 45 days. And the more sinister part is that to meet the 45-day, and 45 days is from conclusion of arguments, the more sinister part, which I may say, and you all must think about this, is that sometimes then judges may start writing judgments in advance just to meet the deadline. In that case, the entire oral hearing becomes a formality. Is that not a serious travesty of justice? And we have seen that. I have seen cases, I'm doing cases in the Supreme Court where a trial judge has been subjected to disciplinary action because it was found that the person had prepared the draft judgment even before oral arguments had been heard. So these are the realities of the matter. And when you get into matters of criminal law and death penalty, they become even far more serious. You've been talking about human rights advocacy. If the draft judgment is ready even before you're arguing the case, what advocacy? It's a moot court then.
Thank you, sir. Do we have any other question?
So my question to sir and ma'am is that how does media coverage of heinous crimes influence the people's opinion and subsequently impact the decision of the judiciary?
Media coverage. Did I hear you right?
Yes, sir.
Look, there are systemically, you would expect judges to be beyond the influence of conversations in the media. But look, as humans, these are bound to have some psychological effect. There's no doubt. And even now, many times you see brave judges who stick their necks out. And I had publicly, in fact, on Twitter, commended the trial judge in the RJ Car case, for example, where there was so much pressure on him to grant death. But he wrote a very balanced judgment, and please read it, I think. And it's, I think, a compliment to the system that a quality of that judgment can come from the trial court. Read that judgment in RJ Car, where the judge walks that fine balance and says, yes, it is a case for conviction, but here are my reasons not to grant death, despite all the societal pressure and how much blowback that judge got. You know, I talked about trolling. As lawyers, when you're doing these cases, you should see at least lawyers at some platform can ventilate and push back. A judge is in that sense voiceless, even with the recent allegations of burnt notes being found at a judge's home. And trust me, that case is more complex than you will think. Media influences all of you also. You'll probably see different versions to that coming out. But for a judge to stick by their conviction, write a judgment, and say, look, no matter how much pressure there may be, to still say it is not a case to grant death, I think is to the credit of the system, and that happens often. But that said, many times, yes, you do see, especially in bail, I think, more than in final orders, because see, convictions, appeals, hearing in the Supreme Courts take place at some distance from the actual event. So many times that pressure wears off. Today, when you're speaking about the 2611 accused being deported and brought to India, somehow the impact of it today is less than it would have been when 2611 actually happened years ago. But at the bail stage, it's more immediate. And there, I think sometimes it can, the pressure can weigh with judges. It's but natural, but it should not.
Thank you, sir, for that question, for that answer. We have a student online who wants to ask a question. May I allow him to unmute his mic?
Hello, sir. Am I audible to you?
Yes.
So good afternoon, sir. So basically, my question is regarding the ST/SC Act. So if you read Section 3, subsection 2 of the ST/SC Act, it says that whenever the ST/SC member has died due to production of false evidence, in those circumstances, there has to be a death penalty given to the offender as a mandate. So death penalty in those scenarios is not discretion, is a mandate which has to be imposed by the court. So this particular thing negates the sentencing hearing which is envisaged in the CRPC and BNSS. So my question is, I think that the trial courts and the lawmakers, they don't have clarity on the purpose of sentencing. Whether we want rehabilitation, whether we want retribution, whether we want the deterrence is something which is not clear in the mind of the lawmakers and judiciary. Because when you give the mandatory death penalty, the first thing, it is being hit by the law laid down by Supreme Court in Mithu Singh case. Second, it is also going to negate the aspect of reformation. It also suffers from the manifest arbitrariness. So how do you respond to this particular PIL which has been filed, which is challenging the wires of this particular provision? And my second question is, so like you mentioned about the Justice Verma committee report on the death penalty. But again, you know what I think, that the deterrence of death penalty is not being queried in India because we don't have certainty for the same. Since 1947 till now, we are about to reach towards the 80th year of independence. How many death penalty have been actually executed? The certainty lacks. So the deterrence will arise when you import death penalty with certainty. In the absence of certainty, deterrence cannot be created. So how do you respond to these two questions? Thank you, sir.
Now, look, certainty, also the mode of execution. There is also a petition pending in the Supreme Court as to whether indeed hanging is the most humane way of carrying out the death sentence. And there is a huge conversation on that. That lethal injection in the US has been actually proven to be a very brutal form of execution, and the jury is out even on that. There's a different human rights aspect there. On deterrence, look, certainty again is a slippery slope. I would not also buy an argument which says we have had 500 death penalty is executed in 80 years, and therefore there's certainty and therefore there's deterrence. Because that statistic is one of those fair weather statistics that doesn't tell you the truth behind it, which is as to how many of those death sentences were actually deserved. Let's ask the question as to how many death sentences have we meted out, which should have perhaps been acquittals. And your earlier question, look, I think that is an open and shut case. There is really no room anymore, in my opinion, to have mandatory death penalties. The law is settled by the Supreme Court in the context of IPC. One would really have to follow that principle in the context of 321A, I think, of the SCST Act, which in one part it says life, in one part it mandates death. I think there's no doubt that that has to go. There's no, when the whole conversation is about moving towards abolition, about being de facto abolitionist, how can you, then it's a bigger square peg in a bigger black hole of our jurisdiction. There's no question about it. There cannot be provisions for mandatory death. And whether, West Bengal tries it or somebody else tries it, that's again, I think, just, strong arm tactics of governments. The law has no room for it.
Thank you, sir, for the answer. Do we have any questions?
I want to add to that. Yeah.
Sorry.
Shreya, would you like to add to that?
No, sir. I mean, yeah, you've said it all, and I mean, just to say, the SCST Act actually isn't 321. While of course on the statute books it reads as a mandatory death sentence. Again, I would encourage everyone to look at what are the provisions which allow for the death penalty, and the provisions under which currently prisoners on death row exist. So as of now, I mean, the good thing is that nobody in India is currently on death row because of a provision like that. But by the way, there are, for a little bit of, I guess, death penalty trivia for everyone, that isn't the only mandatory death sentence provision that exists. There, in fact, is even in the IPC itself, if you were to read section 195A of the IPC, in case someone's already been sentenced to death because of false and fabricated evidence, then that person later on who provided such evidence will also suffer the death sentence, right? So there are other, in nooks and corners, when you see, you will find the mandatory death sentence that still exists. I would in fact encourage everyone to now go to the other end of this mandatory punishments conversation, which is that can we have mandatory life till the end of natural life, or mandatory minimum of life till the end of natural life, which is also currently a pending petition before the Indian Supreme Court. So those are now the conversations where we need to go, and again, something to look at regionally itself. About in April 2023, Malaysia had abolished a mandatory death penalty. They had also abolished mandatory life till the end of natural life. And why I take Malaysia as example is because we have a lot more in common with their criminal policy than other countries that have been cited today in the discussion, because of course Malaysia was also a former British colony, right? So it might be useful for us to, as legal researchers and lawyers, to look at those debates and discussions and what led to that. Of course, a lot of that is something that we can draw into in our own constitutional adjudication.
Thank you, ma'am. We'll have a final question from the audience.
Greetings, dignitaries. I had a lot of questions to ask, but due to time crunch, I'll limit myself just to one question. So Shreya ma'am, you reflected us upon the areas of partial compliance with Manoj K's guidelines in the courts, as well as reflect also upon the mental illness to prisoners in the processes of trials and seeking justice, psychological evaluation, and reports of the interviews which could have been taken and then brought up to court, but that does not hold a lot of intensity. So, in this line of assertion, my question is, how can mental illness during trial be identified and incorporated into judicial reasoning without treating it as a mere afterthought or a formality? Thank you.
Yeah, I mean, see, there's a lot that can be done, should be done, which currently I don't even think we have imagined in our legal system towards dealing with the complexity of mental health concerns and mental disabilities, right? And part of that is, again, what I've said earlier, that we don't have the institutional capacity to do that. So, for instance, if you look at in Australia, and I'm taking examples just to draw like sharp contrast of things that we haven't even imagined, right? In the state of Victoria, one of their procedures is that for a person who shows signs of mental illness or disability, that they would, even during police questioning, that they would have a support person with them, so that they can better engage and understand what is being asked of them, and to help them navigate through police interrogation. Now that is something that, I mean, we're I guess decades away from even imagining something like that, because the question that you're asking is one of at the time of trial and towards um, the end of the trial, for a person's mental illness even to be discovered during that process. That itself is something that is currently not happening, and for us to, as a system, be able to develop something like that, we will need to do a lot to get to that point. So I think that part of this is for us to first understand as a system, to get rid of the way in which law has come to understand mental illness. I think a lot needs to be done there itself, because still we are concerned with issues like, for instance, the McNaughton's rule that has informed the insanity defense, which is basically to say that whether the person at the time of the commission of the offense, whether they understood the consequences of their actions, and that is what defined the insanity defense. Now, in the world of psychiatry, you will find that to a mental health professional, this is something that they will find mere impossible to answer, because after the fact, for them to even understand, to diagnose whether the person would have understood the consequences of their actions, psychiatrists would tell you, and renowned psychiatrists would tell you, that that is not something that, it's a fiction for them, right? It's a fictional question for them. So how should we come to understand this? How should law kind of interact with principles which are outside of the legal discipline? We will have to first and foremost educate ourselves better as legal professionals, as lawyers, judges, prosecutors. Secondly, we will have to take that into the standards that we have developed in the law, because the law will need some standards, some guidance, right? So there is, from the world of psychiatry, how do we move into, how do we let that inform legal standards and legal decision making, is something, again, a lot of work will have to be done. And sir has spoken about the role of non-lawyers in sentencing councils. I think that that same logic should inform the way in which we create standards for different types of areas where other kind of expertise is called in, be it in the questions of mental health and insanity, competence to stand trial, or even expert evidence. So I think we'll need to do a lot of that work to educate ourselves and to inform better standards before we kind of think about solutions which therefore which lead to lesser situations, that people's mental illness and disabilities aren't even discovered, and for us to create a criminal justice system which is more cognizant of that.
Thank you so much for that question, ma'am, for that answer, ma'am. Finally, as we come to the close of this session, this is a question meant for both of you. Since that the fact is that we have discussed a wide variety of challenges within the course of this discussion, which currently plague the administration of death penalty today, we see that a lot of it stems from a disconnect between the trial and appellate courts as the executive machinery and the judiciary. And we also see that a lot of the death row prisoners, they are disproportionately from SC/ST communities and marginalized backgrounds. As far as I remember, the report stated that over 85% of the SC/ST individuals who are currently on death row are poor. They are below the poverty line. And that begs us to question as to which sort of people are currently getting the death penalty and as to why people from a particular strata are disproportionately getting the imprisonment that is meant for the most heinous of crimes. And therefore, my final question to the both of you would be, what would your hopes be for the future as to how we may proceed forward from a current state wherein there's anything but fairness in how death penalty is being meted out? Sir, first of all, we'll hear from you, followed by me.
No, I have, I think, already substantially covered this. And if you'll excuse me, I have to leave now. I'll only say, I think awareness around this is crucially important. So I'm glad that you've picked up a theme like this and are discussing it. Awareness, societal awareness, of course, but I think more pointed awareness within the law school system, within the curricula, I think is important because you'll have now, I hope, younger scholars writing about this, researching on it, and possibly even practicing in these spheres. I think that is where the difference will come from.
Thank you, sir, ma'am.
Yeah, I think I just conclude by saying that it's important that we, as a constitutional democracy, that we now question whether this experiment of the death penalty has worked out and whether it is in compliance with our constitutional values. I believe that it is not, and I think we will soon move to a place. My hope is that we'll soon move to a place where, such a punishment is struck down because there's enough and more evidence to show that it has been a failure. Yeah.
Thank you so much to both of you. Before we deliver our closing remarks, we would just like you to, if both of you are willing to decide if there was any one particular question from the students that you liked so that we could give them our reward for the day.
You decide that.
Shreya ma'am, would you want to?
I'm happy. I'd rather on a topic about death penalty to be arbitrarily taking decisions would be problematic. So I'd let you take the call, Virendra.
You'll have to refer this to a larger bench.
Surely, sir. Thank you so much to both sir and ma'am. It was an honor moderating this session. Now I'll invite one of my colleagues, Vedant, to deliver the closing vote of thanks. Thank you.
Good afternoon, sir. Good afternoon, ma'am. Good afternoon, everyone. I am Vedant Pratap Singh, and on behalf of the Student Committee for Constitutional Law and Human Rights and Pro Bono, I would like to extend my heartfelt gratitude to Dr. Aditya Sondhi, sir, and Ms. Shreya Rastogi, ma'am, for sharing their insight as to the internal workings of the court and prosecutors incentivize death penalties, and for stressing the importance of vigilance by advocates and related officials for motivating death sentence. Today's discussion has not only illuminated on the legal and moral dimensions surrounding the death penalty in India, but also has reminded us for our responsibilities, what we bear as a student and as a citizens to engage with justice in both action and thought. And to our audience, thank you for your thoughtful presence and participation. We hope today's conversation leaves you with questions to reflect on, and courage to keep asking them. I would also like to extend my gratitude towards the School of Law UPS, Vidhi team, who helped us to organize the insightful discussion. And thank you once again, Saran ma'am. And we would like to forward to many more such enriching dialogues ahead, and would love to host both of you on campus soon for more discussions, sir. Ma'am, thank you so much.
Thank you. Thank you very much.
Thank you.
Yeah, book भी दो यार, किसी को तो दो। है ना सर? ये नहीं आप देखिए,